Good afternoon. My name is Hanny Demetrius. I'm here on behalf of Paul Marks from the Law Office of Robert Malo. The issue here before the court is of significant nature, and I am glad that the court has agreed to hear this matter. The issue is when a defendant needs to testify and assist counsel at a post-conviction evidentiary hearing, are the defendant's inherent Fifth Amendment due process rights violated when the court fails to determine competency? I would suggest to the court the remedy is, under these circumstances, due process necessitates the defendant to be competent at a post-conviction evidentiary hearing. The court should reverse and remand for the trial court to have the defendant tested for competency and to proceed with the evidentiary hearing once the defendant is deemed competent.
So court, you're asking for us to remand so that the state would test the defendant for competency, or so that post-conviction counsel would acquire an expert to test the defendant for competency and then report back those findings. Can you clarify that?
Sure, Chardello. I would say that since that this is civil in nature, that if the defendant can afford the testing, then it be on his expense. In the event the defendant is indigent, then he can apply for indigency status, and through the JAC, he can acquire funds for the testing.
Counsel, you mentioned that you would remand because the post-conviction court failed to determine competency. And that's similar to what Lucky, their remand instructions were for the post-conviction counsel to determine competency. They didn't provide any rubric or procedure necessarily in the opinion for doing so. What would you say to the argument that the post-conviction court did determine competency in the middle of the hearing after having heard your client testify to some extent?
Judge, I believe the Lucky court, and if not, at least in Carter, they did reference the criminal rule of procedure that deals with competency, and they suggested, at least in Carter, that the way to deal with competency is in the criminal rule of procedure 3.210 through 3.2112. And as far as the trial court determining competency, I don't think it is within the trial court's purview or experience to determine whether someone is competent. That is someone who has the expertise in psychology to make that determination.
So we would be creating a per se rule that anytime competency is raised in a post-conviction matter, the trial court, who has the benefit of seeing, hearing, listening, observing, is not capable of making that determination, that they would have to go through some sort of process as they would in any action the state brought against the defendant. Is that correct? That's
correct, Judge. Even in criminal court, as you reference, a criminal judge cannot make a determination without the evidence of a presentation from experts and their reports who have interviewed and sat down and have the expertise and use the rubrics in the rules for what fields to test.
But how would we not be expanding in a civil proceeding the law if we were to require that rubric in this case?
Judge, I don't think the court would be expanding. It would be following what due process requires. And one of the issues that have come up, for example, if we follow the rules of civil procedure, in civil procedure, when someone is deemed incompetent, you can appoint a guardian. I don't think that would be applicable here because you need Mr. Marks to testify. You need him sitting next to his counsel to say, no, this is untrue. Ask them this question. I know this point.
Would you concede that due process is a sliding scale, that there's different processes due to different defendants or to whether they're civil or criminal based upon the charge?
Judge, I would say due process is the backbone of the whole legal system.
Would you say that the due process due to a death row inmate is the same as a due process due to somebody who's defending against a traffic infraction that's, $100 or less? Is it the same due process the system affords?
In other words, what amount of process is in fact due?
I would say that in this circumstance, if you're afforded a hearing And the basis of your hearing is what your client has to say about his communications between him and his trial counsel. And those aren't on the record. And he's been granted a hearing on those matters. And the only way to proceed is for him to testify. He has to be able to testify. And but for his mental infirmity, he would have testified that day. And he shouldn't be treated differently just because he has a mental infirmity as opposed to someone who doesn't suffer from a mental infirmity.
Counsel, in Lucky, the fifth DCA seemed to be really moved by the fact that there were so many indicators of incompetency that the trial court should have at least done something. At least that's the tenor that I get of that decision. And they said that it was error not to address competency. In this case, your trial counsel filed a motion both to continue and to have an expert appointed to determine competency. Court heard that motion, and then part of the way into the testimony, the court heard a renewal of that motion and denied it. And then in the final order, made findings about competency. Why can't we say that in this case, the court did address competency so that even if Lucky applies, the trial court already complied with whatever was required and made an initial determination about competency and moved on, as opposed to the trial court and Lucky, who just didn't do anything?
Judge, I would say, number one, going back to Judge Nardella's question, that it takes an expert to determine competency. And if you go back to the trial court's order for competency, what the judge ruled was Mr. Marks didn't have an outburst in the courtroom and he didn't smell from 5 feet away. Those cannot be the rubrics to it. In addition, the person who knows best for competency is him and his attorney, right? I'm the one that's sitting down with Mr. Marks, having that experience, knowing how he's answering, knowing I can't prepare with him. He doesn't know who I am or the proceedings that are going forth. It is the attorney who has that type of experience and time with the client to say, I have reasonable grounds and a good faith basis that Mr. Marks can't proceed under this
When you
condition.
talk about his need to, to get up and testify and tell his story, it seems to me like you're focusing on his competency and his role as a witness, because he's got two roles here. He's a witness and he's a party. And, it's a civil proceeding. As a party, the party can literally be dead, right? Normally in a civil proceeding, competency is in fact not required. There is no due process right for a party to be competent in a civil proceeding. If somebody's dead, we switch out their estate, right? So there would have to be something unique about this civil proceeding where you would, talk about his role as a party, where you would say, okay, because it, collaterally attacks a criminal proceeding, we're going to throw out the normal way we treat competency of parties, and we're going to switch it over to how we treat competency of parties in criminal cases to be the complete opposite of how we treat competency of parties in civil cases. Would you agree with that? That's what you're asking us to do? You agree in civil cases, the party can literally be dead, right? Zero competence, and the case can still go forward, both for or against them.
I can't speak as to civil, Judge, because I'm a criminal practitioner, but what I can say in response to your question, Judge Miles, is to say that if the standard, I'll back up and say 3850 is a very unique animal in the sense that although it is criminal, it's a criminal case that's handled in a criminal court. However, it is deemed civil. So it is a kind of a hybrid of an animal. So when you file the motion and you have grounds, and the grounds in this case were based on the advice of his counsel, Mr. Marks made certain decisions. And the only way to determine what that advice is to create a record, is to hear from Mr. Marks and his trial counsel.
So that's what I mean. That speaks to his role, not as a party in the proceeding, but as a witness.
Well, in addition, Judge Mize, I'd say when you're at counsel, he's also a party in a sense. He has to assist his counsel.
Correct. But what I'm saying, in a civil proceeding, there is in fact no right to competency at all. The party can literally be dead. Like in a criminal case, if the party dies, case goes away because you have a right to be competent, participate in your defense, and all those things, right? Even if you die when it's on appeal, right, your case goes away. In a civil proceeding, if the party dies, plaintiff or defendant, they literally just switch it out for the person's estate. There's zero right for a party to be competent in a civil proceeding.
I would say, just as Judge Ganem said, in referencing Lucky, here you had a defendant who was so far gone, he couldn't even make a presentation and an argument,
That defendant was pro se,
right?
right? So he was acting not only as party and witness, but as, you know, his own lawyer. So in Lucky, the person not being competent means they had no opportunity to be heard because they couldn't present their case because they were incompetent. Here, the lawyer, just like you would in a civil proceeding, right? You can have a completely incompetent client. You can have a dead client, right? But the lawyer is still able to present their case. We don't consider that party unable to proceed. They have an opportunity to be heard through their lawyer, regardless of the party's competence. So Lucky, there was no lawyer through which the party could speak. He was acting pro se. Here, there's no question the lawyer was competent, right? The lawyer was a licensed member of the Florida Bar and was ready to proceed. It was the issue of the party's competence. And in a civil proceeding, there's no right to competence. You can literally be dead. The only other role I could see is the role of witness. But to me, the relevant question is then, how do you handle incompetent witnesses in civil proceedings?
I'd say in response, Judge Myers, we filed a supplemental case, the Branch case, which dealt with a Jimmy Rice proceeding. Again, a collateral civil matter. And in that instance, he was deemed incompetent, Branch. And the judge said, all right, over state's objection, because even the state on hearing him testify said, we need a continuance because he's clearly having issues. The judge says, no, I'm going to appoint a guardian, right? Because it's a civil matter. And there, I believe it was the second DCA said, that doesn't work, putting a guardian there. How can a guardian ascertain as what is in the mind of Mr. Branch in order to testify? So we find the remedy be that he be given a new hearing when he has been restored competency, because there is no substitute for the contents of Mr. Marks's mind in order to have a determination in the hearing.
Well, I was gonna follow up on something you just said. Have the hearing when his competency has been restored. I mean, in this case, for one, there has never been an incompetency determination. Even if the trial court had given time to do that, granted the continuance, there's no guarantee in this case that if the defendant was found incompetent, that he would ever be found to be competent again. So, are you saying that the rule should be a continuance would be required to determine competency and then just held open indefinitely beyond the 2-year requirement for a Rule 3850 motion? What is the end game of this rule? Like, how far does it go to comport with due process as you're arguing?
I would say, Judge Ganim, that how it should have happened is the trial court should have allowed a determination in the competency. Had Mr. Marks been deemed incompetent to proceed, then yes, there would be a stay until he reaches competency. He has a 30-year sentence. He's serving the sentence. So there is no harm to the state or to the victim. His case is resolved. The only harm in not allowing him to continue with the process is Mr. Marks's due process rights to this hearing.
And so, but would the 3850 proceeding then just be held open indefinitely until maybe one day it was determined that he was competent again? I mean, would that be the result of the rule you're advocating for?
Yes, it can have a stay, or procedure can be dismissed without prejudice, and it can be reinstated and told during that time, and it can be reinstated when he gains competency.
But counsel, there are externalities to that rule, right? For instance, the witnesses that the state would call 30 years from their case, they may not recall their conversations.
I have had 3850 hearings where trial counsel has passed away. And there are different ways where, number one, 3850 presumes that the proceedings were accurate and correct. So it's the burden of the defense to overcome those, which is a very big burden typically in these cases. So with that presumption in mind, a lot of evidence such as communications that have been memorialized, in addition, communications that trial counsel has had with state attorneys and in the process, and they're able to still handle those types of issues.
Counsel, we asked the parties to be prepared to discuss the civil standard, the due process standard for granting a continuance or not when a witness is unavailable. We cited to the, I guess it was the Fisher v. Perez case, but generally the standard requires that if it's, you want a continuance because a witness is unavailable, due process requires certain showings to be made, and that would include diligence and obtaining the witness, being able to tell the court a point in time certain when the witness will be available and able to testify, and then it looks at sort of a balancing the prejudices of parties. How would you apply that here? If that standard applies, how would you argue that trial counsel satisfied it to the extent that a continuance would be required for under due process principles?
Number one, in trying to deal with, first of all, I appreciate that the court gave me the alert to know that this was going to be a matter so I can address it. And in addition, Rule 1.460 has those requirements that say, all right, if someone's not available, when are they going to be available? I don't think that that is something that's in the lawyer's control, right? In Fisher v. Perez, there, the expert witness could have informed and did inform the attorney, all right, I will be available in however much period of time. If someone's incompetent, I don't know until an expert tells me, based on my examination of Mr. Marks, he can be rehabilitated or deemed competent in potentially 3 months. I don't know until someone else gives me that information.
If that standard applies, then would you agree that you couldn't even tell the judge that the witness was quote unquote unavailable because you don't even know yet whether that witness was competent to testify?
Well, he would be unavailable because he'd be deemed at that point incompetent. And then the expert could tell me this is when he will receive competency. But in this line of questioning, the fear I have from this court saying there's so much vagueness is treating someone with mental illness different than someone, for example, who has a heart attack. If someone has a heart attack, is a trial court going to continue a case? Most likely.
That's not an apt analogy. When somebody has a heart attack, you can see they have a heart attack. Somebody can really easily lie about being incompetent.
And
right? And that's also, judges aren't medical experts. They are, in fact, experts at evaluating witnesses. I mean, that is something judges do pretty frequently.
I would say, number one, people can, Judge Mize, lie about heart attacks. Not very well because there are records. I see that. But on the other hand, that's why criminal judges have a rule to determine competency, and it requires an expertise because no lawyer has the knowledge to determine competency.
Counsel, you're pretty far in. Do you want to keep going or reserve your time?
I will reserve my time at this point. Thank you.
Good afternoon, Your Honors. My name is James Hellickson, and I represent the appellee, the state of Florida, in this matter. If Your Honors have any questions, I'd be happy to address those. If not, I know we're here to discuss a post-conviction hearing that went forward after the post-conviction court denied the request to continue the hearing when post-conviction counsel filed a motion alleging that the post-conviction movement might have had some inability to communicate with post-conviction counsel prior to the hearing. And based on that, the post-conviction court denied the motion to continue, granted in part the motion to appoint the expert, or not really appoint the expert, but said, if you want to retain the expert, you may do so, but declined to continue the evidentiary hearing, at which point in time, Mr. Marks was called as a witness. He did testify. And then at the end of the proceeding, obviously, the two other witnesses were the first trial attorney who withdrew, and then the second trial attorney who then became a judge between when the post-conviction proceeding began and when the evidentiary hearing took place. They both testified at the hearing as to their role that they played at trial. And based on that, the totality of the hearing and its order denying relief, the post-conviction court found that Mr. Marks was competent during the hearing, and that he was not entitled to relief on the two grounds set for the evidentiary hearing, and it summarily denied ground 2, which involved trial counsel's failure to move for mistrial after the objection to testimony had been sustained.
Counsel,
Yes, sir.
if our post-conviction court had sat in the Fifth District Court of Appeal at the time that this hearing moved forward, should the post-conviction court have done anything differently?
That's a really good question, Your Honor. And I know that there was the Lucky case out of the 5th District, and I know that there was the I've always mispronounced this name, the D'Arcangelo case out of the 2nd District that were cited by the post-conviction court. And the answer to my question on that is, I'm not entirely sure, because what happened after, like in 2013, the U.S. Supreme Court decided a case, Ryan versus Gonzalez. It is 568 U.S. 57. And that, I think, kind of establishes the floor of these competency determinations. And what the court said was, we are going to look at these proceedings to determine first if there is a right, like if the state, or in that case, the federal government had by statute issued a right to be competent in a post-conviction proceeding. And turning to that, they said, no, it did not. So then they turned to the 6th Amendment and they said, well, there's no 6th Amendment right to post-conviction counsel. And incompetency or competency doesn't flow from the 6th Amendment, it flows from due process. So they next considered, was there a due process right? And then they went through this long analysis explaining post-conviction proceedings. And what they ultimately came to the conclusion is that if there is no foreseeable hope for the defendant to be restored to competency, there is no reason to provide an indefinite stay of the proceedings. And so I think that's the floor that the courts operate under now. So
Your colleague would argue that he wasn't even given that opportunity to put forth evidence of whether or not competency could be restored. What do you say to that?
It's a little bit difficult in the post-conviction proceedings, Your Honor. And I say that to say this. So if we go before trial, we know that there are definite safeguards in place. When we spill over to post-conviction, the waters get a little bit more blurry, because Rule 3.850 doesn't talk about continuing an evidentiary hearing or continuing a post-conviction proceeding. And it doesn't allow a motion, it doesn't talk to competency either. So the post-conviction courts are really kind of stuck between, what do we do? Because we can't really determine competency much before these hearings. So essentially, you're going to kind of make a competency determination at the evidentiary hearing. And I think that's within the court's discretion, because the court is in the position to evaluate how the proceeding is going. So the court always has the discretion to stop the proceeding if it sounds like.
What if the guy really looked really obviously incompetent?
There's
no, expert determination for the court to rely on. You just get there and the guy can barely speak. He doesn't know where he is. Would it have been different?
Absolutely, Your Honor. And I say that to say this, is the courts always have discretion in those matters. So if the court.
No, so assume trial judge said, no, we're going forward.
Oh,
That would be different. for us.
yes, it
Yeah.
would be different for you. Yes. Well, let me ask you, can I ask you a clarifying question, Your Honor?
Sure.
Would your question be different if the defendant or the movement was proceeding pro se versus through an attorney?
In this case, so he's same facts as here. He's got an attorney, but the crux of the post-conviction claim he's bringing relies on his testimony. And he just has no idea where he is. He's clearly incompetent. And the trial court says, no, I think he's competent, or I don't think he has a right to competence. And we're going forward. How would this proceed in your view?
Oh, so in that case, Your Honor, you would have a record of the proceeding. So you could identify in the record what the answers to the questions were. So for instance, if the question is asked, why are you here? And he says, well, I'm going to go plow my field at 2:00.
I know, but
Right.
so assume that happens.
Yes,
He's incompetent.
yes,
Trial judge proceeds with the hearing anyways, either because the trial judge finds he's competent clearly incorrectly,
right.
or because he says you don't have a right to competence in post-conviction.
Mhm.
And it comes to us.
Correct.
What do we do?
How do we evaluate?
And that's the struggle that I think the courts wrestle with, because it is so fact specific. And I
Counsel,
think
I'm giving you the facts.
you are.
So I don't want you to tell me it's fact specific. I want you to apply the facts I'm giving you. Give me an actual concrete answer. This is how this would go. This is what the state's position is to what you should do. He's clearly incompetent. That's your facts. Trial court nonetheless finds him competent or determines he doesn't have a right to competence, either one. He's got a lawyer, but he's the key witness for his post-conviction claim. Tell me exactly what we should do.
And it's a really difficult question to answer, Your Honor, and I say it to say this, and I appreciate where Your Honor, the question, but I say that to say this because when this court reverses post-conviction claims, they generally reverse for either for an evidentiary hearing. And so in your scenario, if the court reverses because he's incompetent, the reality is you're just going to hold it, it's going to be in a
Counsel, I feel like this is the fourth time I'm asking.
right.
I want you to tell me what the state's position is as to what ruling we should make in that situation. I want the next words out of your mouth to be, Judge, here is what your ruling should be in that situation.
And it's a tough question to answer, Your Honor, and
If you just don't have an answer, you can say that. If you have no idea, that's okay,
I
but
really don't because
Okay.
I know what the court.
Would you be
Yeah.
arguing that Ryan requires an affirmance, even if let's say the trial judge, take Judge Mines' example,
Yeah.
says, I don't have time for this on my docket, we're moving forward, I don't care if he's competent or not. This is his one shot, we're going.
Yes, Your Honor, in the, I
Does
know what,
Ryan say that doesn't matter?
it does not, Your Honor, and the
Okay.
problem, the reason why I'm struggling with Judge Mize's question is because the court is going to reverse the post-conviction court's decision and say remand. But the remand instruction is where it gets tricky because in post-conviction claims, the remand is for an evidentiary hearing. And so before you hold the evidentiary hearing, if I understand your question correctly, Your Honor, is before it even goes back to remand for that second evidentiary hearing, would he then have to be evaluated for competency? And I think the answer to that question is yes, because this court could look at the record, it could determine that the answers were so far off base.
okay. So your position is the trial judge gets to do, how I take this is, because you're agreeing that if he was clearly incompetent, there should have been an evaluation of competency, right?
Yes,
But that was not the position the state took below, correct? I mean, the state took the position below that there was no right to competency in a collateral matter.
correct. And that is theoretic, it is correct that there is no right to competency in the collateral matter. However, you run into the due process clause, and that's where the framework gets murky because there's no clear due process framework to apply.
So you're saying there may be a right to competency in a post-conviction proceeding?
I'm saying that it's within the judge's discretion to hold the hearing or not hold the hearing, and they have the discretion
If you
to.
have a right to something, how is it in the judge's discretion whether or not that right is honored? Is that the opposite of what it means to have a right?
Yes, Your Honor.
Okay.
And the way that and it gets very tricky because I can tell you what the case law is. I can't tell you how the court is going to rule on that.
Counsel, let me
Yes.
ask you this question. Suppose that we have similar facts to what we had below, but trial counsel had these interactions with the prisoner 3 months before the evidentiary hearing and said, you know what, I think there's an incompetency issue here, and then lined up an expert and had an evaluation done, and then files a motion for continuance. It says, I have a determination in hand from an expert that my client is incompetent. We need a continuance or at least a competency hearing before this evidentiary hearing can go forward. Would there be a due process right at that point in time for the prisoner to get that hearing, to have the competency at least determined before the evidentiary hearing goes forward? Or can the judge say, you have no right to competency in a post-conviction proceeding, I don't care?
Well, I guess to answer that question, it would be, is there a timeline that they think that he can be restored to competency? And not to say that is to say this, because the way that the Ryan case reads is that, can the defendant be restored to competency in the foreseeable future? So I think if it is clear from the record and clear from the expert that the defendant is in fact incompetent, and again, it's going to go to whether you're proceeding pro se or with post-conviction counsel. But if you have that, then I think, yes, the post-conviction court should conduct the pre-evidentiary hearing competency determination and then make a finding whether the defendant is competent or not. And then if competency can be restored in the foreseeable future, and then base its decision on that to grant or deny a continuance, or I guess in that circumstance should probably grant the continuance.
So if the competency determination said, in my professional opinion, and I'm backed up by 3 other experts, this inmate will never be competent to testify again. Would it be within the trial court's discretion in that situation to say, I'm not going to give you an indefinite continuance, either carry your burden at the evidentiary hearing or dismiss your case, but I'm not going to grant a continuance.
I think the proper procedure would be to dismiss it. And then if he becomes competent at some time to refile. And I say that to say this because that's the framework under Ryan is they said that, at some point in time, the state has a right to defend its judgment. And because in post-conviction, we've already had the whole trial. We've already made those, guilt determinations. And at this particular juncture, he's only serving a sentence and there's no right to be competent while you're serving a lengthy sentence. And understand that, this is different from the death penalty case. I understand if you're proceeding under Rule 3.851, they have a different provision that has not been migrated over to Rule 3.850. Maybe the court will someday say, hey, we should have that kind of same procedure in Rule 3.850. Right now, they have not done that. But I think that for death penalty cases, they have said that death is different. And those defendants they proceed under Rule 3.851, I believe it's subsection G for competency. But there's not that same right in a Rule 3.850 proceeding. So like, for instance, if you're serving a life sentence, there's no right to be competent while you're serving a life sentence.
So is the standard that we should apply, the standard that was announced in Fisher, the same as it would be for the unavailability of a witness in any other civil proceeding, so that if, in the example I gave, with the competency determination in hand, and either a prediction that the witness will be competent at some point or won't be, let the trial court consider that and then make a decision within that Fisher framework. Is that how we should evaluate the due process rights involved here?
I think it would definitely help. I can't say because, and I say that to say this. So there have been some criminal cases where the Florida Supreme Court has addressed, whether the Florida rules of civil procedure apply in a post-conviction proceeding. And the only thing that the court has come down and said is that they have discretion. And that's kind of what the U.S. Supreme Court said in Ryan is we're not going to dictate how the courts run their dockets. So they haven't really come out and said what framework applies. And my answer to the court's questions have been, we'll say this, is that the court, a trial court or post-conviction court is not prohibited from considering anything. So if they wanted to consider the civil rules, they could do that within their discretion. Is it a requirement to do it? There is not.
So if the Fisher standard were I can understand whether the rules of civil procedure apply or not. Fisher talks about a due process gloss over those rules. So, okay, we see what the rule says, but due process requires us to really, consider this unavailable witness if it's a material witness before we say, let's go. And one of those elements is the diligence of the party presenting that witness to obtain that witness's testimony. So forget the example I gave earlier where competency was determined 3 months ahead before the hearing. In this case, it was 2 days before the hearing, before something close to that, before trial counsel had any inkling that there was a problem. What else could trial counsel have done to demonstrate diligence in securing this witness? And in that situation where there's no time to do anything, doesn't due process require some grace or accommodation of the problem?
It would be helpful if there were some guidance under the Rule 3.850 as far as like what, because obviously due process, is going to be a little bit of a balancing test, and post-conviction, I think, is going to be even more of a balancing test. And sometimes in the post-conviction setting, you're not necessarily going to know, before the evidentiary hearing. So if, it's really going to be determined on how the witness testifies or is able to communicate to the post-conviction court at the hearing.
It sounds like what you're saying to me is there's a right to competency, but there's not a right to a competency evaluation. Like you're basically saying, let the judge eyeball him, and on an abuse of discretion standard, if the judge thinks he's competent, that's within the judge's discretion. If the judge doesn't think it's within the guy's competent, or if he does, but he abuses his discretion in finding that, then there'd be some competency procedure of which is indeterminate. Does that basically sum up the state's position?
Yes, Your Honor. And the reason I say that is to say this is because under the Rule 3.850 framework, they haven't migrated any of the other rules over. So there's a really good case that wasn't cited in any of the briefs out of the 5th district that talks about the rubric for granting the continuance, which I think is on point with what Your Honor was explaining about Rule 1.460, I believe it was. And there's a list of factors that they consider, and it would be great if a court would say, hey, look, when you're, determining in a Rule 3.850 hearing or before a hearing, consider these factors for unavailability. And the courts unfortunately haven't done that. Maybe this court will be the first to say, hey, look, let's look at these 4 factors or several factors to help us guide our due process argument.
If you have a right to competency, but it's not based on an evaluation, it's just based on the trial judge eyeballing somebody, how is that effectuated? So are we inventing a procedure for evaluations after that? Or can the trial judge just bring it back 3 months later and eyeball him again? And say, well, he looks competent to me now.
Mm-hmm.
Like if it's based on the judge eyeballing, why wouldn't that be the case for however long it is? Can the judge just say, well, I'm going to be in this division for 3 years. I'll bring him back every 3 months. If eyeballing is the standard rather than some type of competency evaluation, is that always the standard? Or as long as the person is pursuing their post-conviction relief, or are we required to invent some type of competency evaluation proceeding that doesn't otherwise apply in these contexts?
I mean, I think if you're talking about a pretrial right to competency versus a post-trial right, the pretrial right would say, yes, you'd go through with the whole evaluation
We're
process.
post-conviction, right? So
Correct.
you basically told me he's got a right to competency, but it's not an evaluation. The judge eyeballed it. It seems to be the state's position. And so I guess I'm just saying, if the judge eyeballs it, is that just a standard throughout the post-conviction proceeding for however long he stays incompetent? Is there some point at which we conjure up some method to put him on the competency evaluation track that you use pretrial? How do these things line up?
That hasn't really been played out in the case law, Your Honor. And so I don't have a clear-cut answer for you. I'd be speculating at this point, which I'm happy to do to entertain Your Honor's question. But from the case law, they haven't really provided that sort of framework to go off of. So I'm really not sure how to answer your question, Your Honor, and I'm not trying. I'd love to give you a concrete answer on that. I really would. I'm trying to stay within the frame, with what the case law says, and I just don't have a good answer because I can tell you how things work pre-trial. They haven't spilled over to post-conviction, and so I don't know if there would be the same right to an evaluation that you have pre-trial, post-trial. I would love to tell you, yes, that would, you can do that. Have an evaluation, appoint an expert, things like that, but the courts haven't come down and said, do that. So I can't tell Your Honor that is the proper procedure to do. If there had been a case that said the court should have appointed an expert in this situation, and I knew about, I wouldn't try to misrepresent the court, Your Honor. If I knew about the case, I would tell you. And if that's how it came down.
I guess the issue is normally when parties are asking us to do something, they have a position as to what we should do, and they want us to rule in their favor, or if we're going to set forth some rule, how that rule would work out in practice. And it seems this position of the state is we don't have a rule and we don't know what we're asking you to do. Is that inaccurate?
Well, I can tell you where the floor is. As far as a procedural rule, no, there isn't one. So, obviously the state will be asking to affirm the post-conviction court's decision because from the record evidence,
I know, I guess what I mean, I don't mean a rule of procedure. I mean, the rule of law you would like us to make in this case.
You can finish, you can answer,
Yeah.
and you have one more question
Yeah.
in counsel.
Okay.
I know you want an affirmance, right? Whether it's opinion or PCA, you want an affirmance. But whether we write or don't write, the rule of law we would be applying, what's the clarity on the rule of law to govern this circumstance that the state would like us to apply?
Your Honor, may I proceed outside the briefing inside a case, or do you want me to stay within the briefing?
If you've got a case, I'll hear it.
I would point Your Honor to Myers versus Siegel. It's 920 Southern 2nd 1241 out of the 5th district. It's a 2006 opinion. I think they go through a lot of really good factors to consider in evaluating the continuance. And if the court were going to adopt a rule or look at something to say, hey, how do we guide our due process? I think they go through a lot of really good factors. Do you want me to cite some off, or are you okay with me just citing the case?
I think we're okay, counsel. You have
Okay.
one more question for Judge Gannon.
I just, understanding that this kind of started with Carter extending this right to competency in death cases. Carter explicitly tied the right to counsel, and they said, unless the death row inmate's able to assist counsel by relaying such information, the right to collateral counsel as well as the post-conviction proceedings themselves would be practically meaningless. Are we free to announce a rule that says if it's a proceeding where you don't have a right to counsel, you also do not have a right to competency? And at most, all that the trial court's required to do is what I think we can glean from Lucky is to address it. If it's raised, have a hearing, but there's no right to competency unless there's also a right to counsel. Would that be a fair rule under Supreme Court precedent and our Florida Constitution?
That's a great question, Your Honor, because I know the Florida Constitution isn't necessarily considered in conjunction, or I guess the correct word is in parliament material with the United States Constitution in those situations. And I say that to say this because going back to Ryan, and I hate to keep going back to that case, but they didn't track the right to competency to the Sixth Amendment. They tracked it to due process. So I think in the way that the death penalty cases have worked is they've applied Rule 3.851, subsection G. Now, if the court wants to, or this court wants to look to that rule for guidance, I don't see why it would be prohibited from doing so and saying, hey, look, here's how courts have interpreted Rule 3.851, subsection G. But as far as like extending that right under the Florida Constitution, that you have a right to competency and a right to post-conviction, it gets a little bit blurry because, and I say that to say this, because the courts have routinely held that there is no right to post-conviction counsel. So the Sixth Amendment doesn't apply in post-conviction proceedings. And so we get to these things by saying, well, it's a proceeding against, as the Supreme Court would say, a warden against the prison or against counsel in some cases, because essentially it's a civil action against counsel. Now, I just want to make one quick, I know I'm way over time, but I just want to conclude real quick. It's a civil proceeding, Your Honor. So I know that what the courts have said is that there are those rights they migrate through due process, not necessarily the Sixth Amendment. So I can't really talk about how the Florida Constitution would apply because they've always kind of said there is no right to post-conviction. And technically there is no right to a post-conviction proceeding, no right to post-conviction counsel. If Your Honors have any other questions, I know I'm well over time. Okay.
Thank you, counsel.
Yes, Your Honors. Thank you very much for your time.
All right, counsel, I'm going to add 3 minutes and 47 seconds. It won't show up there, but I have it here.
Thank you, Judge Nardola. Due process is an inherent right. There's no question about that, and attaches to every proceeding. And from that is birthed the right to competency. Why?
Counsel, could you address the issue of the right of due process varying depending upon the actual proceeding that you're in?
So I think a lot of the courts have had issues, for example, because Carter said, well, it's a death penalty case.
Yeah.
And that's why it's different. However, Lucky has said the idea of due process that applies in Carter still applies to regular 3850.
But the procedural rigor, because we're talking about procedural due process, not substantive process.
That's correct.
Procedural due process, the rigor that a death row inmate is entitled to. Is it your position that that exact same rigor applies across the board to any defendant in the state system, no matter what the charge or what the proceeding?
Yes, because due
And does that
process.
square with the fact that we have legions of case law talking about heightened standards of due process when it comes to death row inmates? I mean, I find law review articles back from the 1980s talking about super due process.
What I would say, Judge Nardella, is due process is a fundamental right, and it gets overlooked because it's kind of intangible. It's ethereal. However, it's fundamental fairness, right? How can one party
What does
have
that
all?
mean?
Well, counsel, you're giving us a lot of latitudes. So due process is 2 words. It's process and the amount is due. Okay. The amount of process due in one situation is not the same as the amount of process or the type of process due in another situation. So in some cases, there's rules that tell you for specific proceedings, and in some cases, there's a constitutional floor, right? And so what we need is not the fact that due process is important. Nobody disagrees that due process is important. What we need from you is, why was this particular level and type of due process due in this proceeding? Do you see the distinction I'm making?
Yes, fundamental due process allows for me to show up here with my client who's a witness and allow him to testify on the stand and he being able to do so.
Oh, there's due process in civil cases, correct? The parties
Yes.
in a civil case are entitled to due process. Can you cite me a single case where this is the problem and a court has said that it is a violation of a plaintiff or defendant in a civil proceedings due process right?
Yes.
Okay,
All right. What Mr. Ellingson cited to the Myers case, in there specifically, it says where the physical or mental condition of either counsel or client prevents the fair and adequate presentation of a case, the refusal to grant a continuance is reversible error. And that's a product of Rule 1.460. And I'd also say in the Branch case in footnote 4, it says, although Carter was a capital post-convictional proceeding, that case did not hinge on the fact that it was a capital proceeding, so much as that a defendant must be competent to assist counsel when there are factual matters at issue and are not of record.
All right, so counsel, in the civil context, so you cited us that language. In the civil context, if you were to seek a continuance on the ground that somebody had some type of a competence issue, the remedy is not to get a competency evaluation, right? There's no competency evaluations for witnesses and parties in civil proceedings, unless the civil proceeding is about competence, right? If somebody's, guardianship or something. But plaintiff versus defendant, and, somebody got a concussion yesterday and now they can't testify. There's no remedy for the state to provide competency, and there's no competency evaluations that take place in the circumstances, are there?
Well, I would argue that that's why the Lucky and the Carter cases both referred to the criminal rules of dealing with competency.
But those
to
cases do
come up
not
with
do
that.
1.460, right?
No,
So that's the thing, we're trying to, you just pointed us, we said in the civil context, how do you get there? And you said 1.460. But 1.460, when that applies, there's no competency evaluation. That's not a thing that happens in plaintiff versus if you got an auto accident case and one of your witnesses got a concussion yesterday and they can't testify, they're incompetent. You might get a continuance, but it's the judge deciding that. There's no competency evaluation on that witness or on either of the parties, is there?
and that's why 3850 is quasi criminal, right? That's why it's in a criminal court with a criminal judge, and it's a criminal based rights and ideas.
But
However,
it
it's a
doesn't say
civil
use the
matter.
pretrial competency rules. does it?
No, and the difference is, if you go to the Jackson case that Carter cited to, in there, Jackson essentially says, this is how competency plays out. In the pretrial area, you have to know, a defendant has to know what's going on in the consequences. Once it gets to direct appeal, he doesn't need to be competent because everything's on the record. However, when you hit 3850 and you're presenting new facts, right? It's not just record based, then you need the defendant to be competent in order to create that factual record. And what the state referenced, the Ryan case, that doesn't apply here at all, because those are dealing with state death row inmates who have filed 2254 habeas petitions. Those are all record based, right? They go back in the record and they see what errors have happened and they
thank you,
submit
counsel. I think we
those.
appreciate that distinction. Does anybody have any further questions? I allowed it to go over the amount already extended.
Thank you. I appreciate your honor's time. And I will say that all three of you look much better in person than on YouTube that I've watched.
Thank you both for your time. We are adjourned.